Hello, and welcome. It's my great pleasure to welcome you here to the 27th Nigel Walker Lecture. My name is Nigel. I'm the Director of the Institute and the Multiple Professor of Criminology. And it's my pleasure and delight to chair this evening. Before we begin, I just have to say a word on housekeeping with respect to health and safety. The fire exits are on both sides here. They're difficult to miss because they're actually the only exits. But just so you understand, these are the two fire exits. The Nigel Walker Lecture was established in 1997. In honor of Professor Nigel Walker, CDP, the Institute's second director. He served as the Woolston Professor of Criminology from 1973 to 1984. And each year this lecture is delivered by the leading criminologists who addresses a topic relating to criminal justice, to crime prevention, or the causes and prevention of crime, or to penal ethics, I should add, especially today. It's our keynote event each year, and it's a very special occasion for the Institute, and it brings together people from all stages of involvement with the Institute, from students to emeritus professors. Now, it's also a valued tradition of the Nigel Walker Lecture that it includes the presentation of the Nigel Walker Prize. The prize is awarded annually for the outstanding PhD thesis completed by a student at the Institute. And it was established by a generous request from the late Sir Julian, of course, the founder and director of the Institute of Criminology. Now, the winner of the prize this year is Kanupriya Sharma. Kanupriya joined the Institute in 2017 as a master's student, and in 2019 she was awarded a Gates Cambridge scholarship to pursue her PhD under the supervision of Dr. Caroline Lansky. In 2020, she founded the Cambridge Decolonizing Criminology Network and was awarded Vice Chancellor's Social Impact Award in 2022 for exceptional achievement and commitment to positive social change in academia. It's a great pleasure to recognize the outstanding doctoral thesis with the title Domestic Chains, Pastoral Lives, Women's Pathways to and Experiences of Incarceration through the Lens of Love, Marriage, and Kinship in England. This work is distinguished by its originality, intellectual depth, and exceptional quality of scholarship, based on extensive and challenging ethnographic fieldwork in prisons across northern India. It offers a compelling and deeply human account of the lives of incarcerated women, grounded in careful, sensitive, and rigorous research. I think the thesis makes a significant and lasting contribution to the sociology of imprisonment by demonstrating how women's pathways into and experiences of incarceration are shaped by the intersecting forces of kinship, caste, patriarchy, and moral expectations surrounding love, marriage, and honor. In doing so, it challenges assumptions and advances a powerful, contextually grounded perspective that will influence the field for years to come. It's a privilege to recognize both the excellence of this work and the remarkable achievement of theirs. Kanupriya is now a postdoctoral research fellow at the University of Nottingham, where her current work focuses on ethnicity and resistance, exploring how racialized and minoritized individuals navigate processes of leaving crime behind, and how broad social, cultural, and institutional dynamics shape these journeys. Kanupriya, my heartfelt congratulations on behalf of the Institute, and my very best wishes for the future. Now, I would like to invite you to say a few words if you like to. You don't have to. But you're very welcome to come here and
Good evening, everyone. I was asked to prepare this very last moment. So if it's slightly all over the place, forgive me. I'm honestly very, very humbled to receive the prize. Those who know me in the room also know that it's been a very roller coaster journey for me, intellectually, academically, emotionally, and personally. So standing here today does not feel like an individual achievement. It feels like a collective achievement because it is because of all of you and many people who are not in the room that are here today. There's so many people I want to thank, but I want to first begin with obviously my supervisor, Caroline, who has been an absolute rock throughout this journey. Caroline, your belief in me, your patience throughout the process, your steady support means a lot, especially through moments when I genuinely doubted myself. Ben, who's been also my internal examiner, thank you for engaging with my work so generously and so constructively. And I'm ever so grateful. I've always looked up to your work, so it's been a real honor. Also, Justice, who's not in the room today, but he's somebody who I could just walk into the room, just barge into his room and just discuss anything. And he's always been there for me. It's like a support system and man, for challenging me and constantly encouraging me to think outside my comfort zone and for giving me the room and support to begin the Decolonizing Criminology Network. And also, Lorraine, you for letting me start the network under your leadership. I'm very grateful for all the encouragement and support that I've got throughout the years. Many people who are not in the room today. Julie Lawson, who was my MPhil supervisor, who's encouraged me to apply for the PhD in the first place. Arushi is also not in the room, always been a great support system. Oh, yeah. Betty, who I thoroughly miss in the room today, because of her, I could not, if it wasn't for her, I could not have completed this PhD. And most importantly, I want to thank my participants. This research would simply not exist without the women who trusted me with their stories, their vulnerabilities, and gave me their time and let me into their lives at a moment when COVID had hit. So it means a lot. It's for them, this award, everything is for them, and many others from my community whose voices have always been invisibilized. When I came to Cambridge, I was searching not only for academic growth, but also for a sense of purpose and belonging. So the Institute gave me that space. It was my family away from home. And through the people I met here, I feel like I finally found my calling. And this place has given me so much intellectually, politically, and personally. When I first arrived during my master's, I was the only Indian in my cohort. And today, when I see around, I see so many more. That means something very personal to me. And I hope this journey and perhaps this moment makes way for others like me. People who may not always feel like they belong in these spaces, but whose voices, experiences, and scholarship deeply matters. So this is for all of you and for people who are going to come after me.
So now, it is my great pleasure to introduce our guest speaker tonight, Professor Julian Roberts, Emeritus Professor of Criminology at the University of Oxford, and Executive Director of the Sentencing Academy. A leading international authority on sentencing theory and practice, with particular experience in public opinion and criminal justice. Professor Roberts has made landmark contributions to the study and practice of criminal justice across common law jurisdictions. He served, amongst others, as a member of the Sentencing Council for England and Wales for 2010 to 2018, and has advised major law reform initiatives internationally, alongside an extensive body of scholarship spanning more than 4 decades and including numerous academic books and edited volumes. In recognition of his exceptional contributions, he has been awarded the American Society of Criminologists Selwyn Rickard Award in 2021 and was appointed King's Counsel Honorary in 2022. This evening, he will invite us to reflect on sentencing as it has developed over the past 4 decades since Nigel Walker's seminal book, sentencing law, policy, and practice. And you will consider how well the current system is functioning and to think critically about the direction it may now take. Julian, it's a great pleasure to have you here, and we're all very excited to hear what you are going to tell us.
Thank you very much. Thank you very much. I'm very grateful to the director and faculty of the Institute and the chair of the Law Board for the invitation. It's a great honor to give this lecture, obviously. It's also a great pleasure for me personally, because being, how can I describe myself, a veteran, I knew Nigel and benefited from his advice on many an occasion in person, and of course, also his books. I think he disapproved of me slightly because he suspected me of being a retributivist, which he wasn't, of course. But in fact, he was my invitation to, he was the reason I first came to Cambridge. I wrote to him as a young scholar with 2 very forgettable articles on my CV. And I asked him if we could come and talk to him about sentencing. And he said, of course. So I came to Cambridge, and not only did he give me an hour and a half of his time, but then took me over to King's College, of course, to have lunch. And then we went into, I think it's called a combination room here, common room, we call it in Oxford, which was really crowded. And it's hard to hear him. But he got out this huge Cuban cigar and lit that, and the room cleared in minutes. But it wasn't just Nigel. I mean, thereafter, I wrote and visited Cambridge. And the next person I spoke to was Sir Anthony Bottoms. Thank you, Tony, for coming tonight. And Tony gave me lots of his time, and he had a huge amount of work to do, of course. And that spirit, of course, captures the Institute and the faculty. And I've come back and visited on many occasions, and on one sabbatical visit, taught a course here, which I thoroughly enjoyed. Enjoyed staying at Pembroke College as a visiting scholar. So I've got a huge amount to thank the Institute and the faculty for, more than just the invitation today. And I'm sure everyone here has also benefited greatly over the years from the Institute. Current state and future state of sentencing in England and Wales. I'm going to be talking about, well, I should explain the asterisk, first of all. The asterisk. Sentencing scholars south of the border have tended to focus, and I'm one of the worst offenders, on England and Wales, and that usually means England. But of course, there's a lot going on in the other nations. The sentencing in Wales is quite distinctive in many respects. And of course, in Scotland, there is a Scottish Sentencing Council, which has been in existence for 11 years, I believe now, has been issuing guidelines. I'll talk a little bit about them later on. But just to make the point that it really should be sentencing in the United Kingdom. I'm happy to say I'm taking some remedial steps, working on a book with Gabrielle Watson and Richard Martin from LSE, which is sentencing in the United Kingdom. But today it's primarily and perhaps exclusively England and Wales. So I just make that a statement. I'm going to be talking about my research, but also the research of others, research by others and with others. And I've worked with a lot of, I've been very lucky to work with a lot of collaborators, many from Cambridge over the years. And I want to acknowledge that debt at this time. Sentencing, of course, is a particularly hot topic at the moment. And it's a particularly good subject for the Nigel Walker lecture, not just because Nigel Walker was such an influence in the area of sentencing, because the Institute and faculty members have contributed hugely to sentencing scholarship over the years. Too many scholars to enumerate. And I think that needs to be acknowledged. Now, I'm not going to go through mechanically all these questions, but I have them in the ether, as it were. Speaking of the ether, I think there are people online somewhere. I can't see anything. But if there is anyone there, thank you for signing on. Just want to keep these questions in our minds as I go through, and I'm particularly interested in, with the greatest respect to Nigel, to proportionality, retributive proportionality, and I'll be addressing some of these issues, and I'll end on the question of democratic accountability. Some people in the United Kingdom feel or felt there was a democratic deficit, which has now happily been filled by a previous Lord Chancellor, and so we'll look at that as well. State of sentencing in 2026. Well, I want to talk a little bit about current practice. I want to talk about the problem of sentence inflation and the overuse of imprisonment or the use of imprisonment, and then public knowledge and opinion. And these two, I think, are two of the more intractable problems or issues confronting us in sentencing in England and Wales. And when I say intractable, I think that they're going to be very hard to address. There are other issues too. Sentencing differentials for minorities. We have taken some steps to address that. The failure of perhaps the environment, the sentencing environment, to be more sensitive to gender. And I won't be talking about gender in this lecture, and the simple reason for that is Graham Gelsthorpe gave a fantastic lecture a couple of years ago on sentencing and women, and I can add nothing to what she said at that time. So those are two intractable problems. Now I'll talk about the council and its guidelines a little bit, and then have some reflections on the Sentencing Act. And then we'll open it up to questions, because it's always a very informed audience, and I'd like to hear your views, obviously. But just, just a note that time has passed. This is from Nigel Walker's book in 1986, and when was the last time you heard a Home Secretary making efforts to persuade sentences, to shorten sentences? And even the Court of Appeal doesn't often encourage greater restraint or parsimony with respect to the use of imprisonment. But as you can see from his quote, things were different back then. So sentence inflation. So what is it? I mean, prices go up, sentences go up. When I refer to sentence inflation, I think we can distinguish legitimate sentence inflation, where sentences have become more severe because the profile of defendants being sentenced has changed. Crimes are more serious, offenders appearing for sentencing have longer criminal histories, or are less likely to plead guilty and benefit from the reduction accruing from defendants who plead guilty, and so on. And so we would expect sentencing to get a bit tougher if that was the case. And then we've got sentencing inflation, which might be illegitimate. That is to say, where sentences just get tougher for no apparently obvious legal reason. And that, of course, is the problem that a number of scholars and 4 senior judges brought to our attention more recently. So here is the increase in sentence lengths. Of course, the use of imprisonment is composed of the probability of going to custody and the average custodial sentence length. But as it happens, most of the inflation, most of the increase in the use of custody has come about by an increase in sentence lengths. The custody rate, even in the Crown Court, has been quite stable. So for some reason, sentences are getting longer, and that's the cause of inflation. And you can see it here, indictable offences. These are data, the next few slides, from the Sentencing Academy, and so I'd like to acknowledge my colleagues at the Academy for their input. And as you can see from indictable and either way offences, there's the increase in imprisonment, in this case relative to 2005, and it's quite clear. imprisonment index, combining the two, combining the ACSL, the average custodial sentence length, with the probability of imprisonment to have a single index, reveals the same pattern. And as you can see, going from 2005 to 2024, there's the increase in the use of imprisonment. And so, well, what's accounting for it? Jose Pina Sanchez, one of the academics who's from Leeds, one of the world's leading quantitative sentencing experts, who works with us at the Academy, has conducted this analysis. And basically what he did was to take a measure of the overall seriousness of all cases appearing for sentencing. He used the ONS index to take the sample of offenses at any particular point in time and came up with an index or a measure of offense seriousness. And then tracked that over time. Now, it's not a perfect index. It doesn't include criminal history, and it doesn't include guilty plea rates. But we looked at those separately, and the criminal history patterns are stable, as is generally the plea rate. So it's a pretty good measure of crime seriousness. And so what this graph shows you is the discrepancy between the increase in severity and the relatively stable pattern of offense seriousness. So something's going on there. And the question is, well, what explains that? And perhaps more tellingly, what's the remedy? If the courts are using imprisonment to a greater extent, what's the remedy, and who is going to remedy this problem? Who's responsible for sentence inflation? Now, the four senior judges, three former Lord Chief Justices and Sir Brian Levison, pointed the finger at the government and documented that accusation, pointing to various legislative interventions, including Schedule 21 of the Criminal Justice Act, which increased, which created higher starting point sentences for people sentenced to life imprisonment for murder, various other interventions in terms of higher maximum penalties and so on. So the government clearly has a role to play. Some academics are pointing the finger at the council. These guidelines are sort of inflating, and I think the research on that issue is relatively clear. And independent academics and the council itself, of course, have examined sentencing patterns before and after the introduction of a particular guideline. Of course, the council does that for every guideline that it issues. And Jose and other academics have also taken all the guidelines together and seen whether there was any impact on the use of imprisonment or punitiveness more generally, and found none. So to sum up this problem, it's still a bit of a mystery. It's clearly there is pressure coming from revisions to the penalties strategy and an uplift from Schedule 21, but there remains a bit of a mystery as to exactly where the problem's coming from, and therefore makes it hard to address the issue. So let's turn to the public now. We'll come back to sentence inflation later. Current state of public opinion, Sentencing Academy and YouGov and various other organizations have done a lot of research over the last few years. And here's a typical finding. I call this the second intractable problem, because the findings I'm going to show you have been stable for an awful long time. Here's the perception that the crime rates are going up. In fact, the correct answer in bold, as you can see, is that crime rates are somewhat lower now compared to the last 25 years, although, of course, some offenses have increased and some have declined. But obviously the public don't see it that way. And most people think, and this is pretty obvious, that sentences are too lenient. And that's a recent survey by the Academy. And I've graphed here the percentage of people, it's the top purple line, who believe that sentences are insufficiently harsh, are too lenient. As you can see, it's been pretty stable, around 2/3, going back to 2019. But we can go much further back. When Mike Huff and I placed this question on the 1996 British Crime Survey, now the Crime Survey of England and Wales, the figure was 67%. And if you track it over the period from 96 to the present, you'll find very little variation in public responses. So that's opinion. What about knowledge? Well, we've seen the increase in the sentence lengths. So we asked the public, the Academy asked the public, has the average prison sentence become longer or shorter or stayed the same? And as you can see, people think not only our sentence is too lenient, but they're getting more lenient. So this is a disturbing perception. We asked them about the number of years that life prisoners would serve, and that's increased significantly. The last statistics I saw, I think from last year, showed that in 2005, the average minimum term for a person convicted of murder and serving life imprisonment was 13.5 years, and now it's 22.5. A big increase, but of course the public see exactly the opposite. So we asked people, it's obviously been getting shorter, but on average, how long do offenders convicted of murder serve in prison before they're eligible to apply for release on license? And it's pretty astonishing that 1/3 of the public estimate that people convicted of murder would serve 10 years or less. And we find the same thing for individual offenses. 95% of people convicted of rape are imprisoned. And as you can see, almost half the population, the sample population, think that the figure is 25% or less. How can that be? Average sentence length, underestimated again. And back to 1996, exactly the same pattern of underestimation of severity. This is from as you can see, the crime survey, British Crime Survey at the time, 88% providing a large underestimate of the average, of the custody rate for domestic burglary. So that's a big problem, and it's obviously existed for a long time, and it's therefore in my category of intractable problems. Some of you veterans like me may remember Chief Scientific Officer for the Home Office, Chris Nuttall, that name rings some people, and he was very concerned about this in the mid-90s, and he had this idea to put posters in the underground, posters in the tube of average sentences and custody rates. He never actually got around to convincing the Home Secretary. Let's take a look at the council, because then we might say, well, what can the council do about this? What can the council do about sentence inflation, public misperception, and so on? And this is where I just note that when I say the council, I'm referring to the English council, but the Scottish Sentencing Council has also been very active over the last decade. They issued a number of offence-specific and a very interesting sentencing process guideline. They've published a number of research reports, held a number of public events. And so there's a lot going on up north. And the Scottish Sentencing Council has adopted a different approach in its guidelines. And although there are echoes of the English system, there are important differences which reflect the Scottish judicial culture. So I just want to recognize that. And as I say, in due course, we will know more. There isn't a great deal of scholarship yet on the Scottish experience, but hopefully that will pick up. So I'm not going to trot through all this, but it strikes me that there's no obviously single model of what a council should look like. There's no single best practice guideline, but I think we can agree, or at least I, having looked at guidelines around the world, and I should again acknowledge a book on guidelines appeared last year with Ari Freiberg and Reese Hester And my thanks to them for their cooperation, and I'll be drawing upon some observations in that book here. Sentencing counsel should have certain key features, and obviously I've highlighted one which is currently relevant and in bold. Legislative foundation, judicial majority, we can talk about that. Some people feel that a judicial majority is not a good idea. I think it's necessary. And broad stakeholders, including people previously sentenced. There isn't such an individual on the English Council or the Scottish Council, but I think, and there have been proposals, I believe, Tony, you made that suggestion. Other people have said there should be somebody on the council representing that particular community. Significant research capacity, the council certainly has that. Public consultations on all guidelines. And I'll talk about the consultation process. And the council contains such expertise, all these stakeholders, experienced members of the judiciary, should be advising, the government should be asking it, private members, individual members of parliament should be asking it for advice. I'm thinking of introducing a private members bill. What do you think? That there should be, it could do a lot more if it was asked to do it. Guidelines should be comprehensive. They should cover all aspects of sentencing. They should be flexible and tailored to the specific offence. There should be some compliance requirement on a court. Otherwise, they're just advisory, and the experience in other jurisdictions is that advisory guidelines don't have much effect. They should be evidence-based. They should reflect the latest research on the effectiveness of sanctions, and they should be subject to ongoing scrutiny to ensure that there are no adverse effects. The US guidelines, I'll just briefly mention Minnesota, they've been operating as they have in several other US states for 45 years now, and they seem to be working well. Practitioners in the state of Minnesota work with them, judges accept the guidelines, apply them, and so I think Minnesota would consider their guidelines a success. But I just want to make the point that generally speaking, the architecture of the US guidelines has remained relatively stable. Nothing very much has been changed. Here's the first and the latest grid, sentencing grid, seriousness and criminal history. As you see, it's been flipped. So now we've got the more serious offenses at the top. But apart from that, the architecture of the grid is pretty well the same. Even some of the sentence lengths are the same. Non-residential burglary and so on. So many of them have gone up. And I think that's probably a mistake, because guidelines should evolve. In other jurisdictions, they do evolve, and quite rapidly. But there are many other models in South Korea, one of the about 45 jurisdictions now that operate guidelines. Simple structure, mitigated and aggravated ranges. Court decides whether the case should be sentenced within the mitigated range as opposed to the aggravated range. Not a great deal of other information, but a useful system. And apparently judges in South Korea appreciate their guidelines. The English guidelines, however, are different. And I want to make 2 points here. One is that they are individual. They are offense specific. And I think that's very important. The second thing is, unlike the US guidelines, where we have criminal history and crime seriousness, the English guidelines, of course, are, I'll see in a minute, there we go. The two dimensions are harm and culpability. And those are the two components of a proportional sentence. So our guidelines implement proportionality far more directly, I think, than the American guidelines, because I don't know, not many scholars would agree that criminal history is a good proxy for culpability. It's risk, it's all kinds of things, but retributive scholars tend to reject it as a measure of culpability. And our guidelines use harm and culpability. So there's a more proportionality oriented, that's my point. And I won't go into details, but the way the guidelines operate, they promote proportionality. For example, at the first step, when a court has to assign the case to a category of harm and culpability, there are factors. These are the most important factors at step one. They are the factors which are primary to the offense and the factors that are most proximate to harm or culpability, or they should be. And when these factors are privileged at step one, this will promote proportional outcomes. And as the guidelines have developed, and of course there are 9 steps generally, it changes a little bit. There are other ways in which the guidelines will constrain the impact of non-retributive factors. So criminal history is constrained, although it's a statutory aggravating factor. It appears at step 2, and the council has issued guidance to interpret prior convictions and to ensure that they don't carry excessive weight, which many people believe they do in the US. And of course, there's also a guideline which restricts, I'll come back to it later, which restricts the magnitude of a reduction for guilty plea. And that's a contentious area of sentencing law, of course. But if you allow guilty plea reductions to hit 50, 60%, then offense-based proportionality is undermined. And so there needs to be some constraint on that in order to protect proportionality, and that's accomplished through the guideline. I'm going to skip over a couple of these. Transparency. So that's another requirement of guidelines. And I think it's an important feature of the English guidelines. Now, of course, there's a great deal of pushback from academics on the time-based guilty plea reduction scheme. Criticisms such as it forces defendants to enter a plea early. They feel pressured. This may lead to wrongful convictions and so on and so forth. And it's one of those areas where practitioners and academics are quite separate. Practitioners, at least members of the defense bar, have a quite different view. I'm not going to pronounce on that debate now, but I do think it is useful to have a public-facing document which explains to the public, to defendants, their legal advisors, exactly what the reduction is. That's not my phone, by the way. Exactly what the reduction is. Now, maybe it's too high, maybe it's too low, maybe the higher reduction should be on the table for longer and so on. But transparency, I think, is a key characteristic of a healthy sentencing scheme. And the last thing I'll say about guidelines is they do permit the council to take some remedial steps now. Imprisonment in ethnic minorities has been an issue since Roger Hood's book in 1994. Race and sentencing. Here's some latest data. Expected custodial sentence, that's just like the imprisonment index, where we combine the probability of going to prison with the average sentence length. And as you can see, the expected sentence length, the expected custodial sentence, longer for visible minorities. And that's been the case for a while. That's an aggregate. And of course, there's a lot of research now showing offenses where it's much greater, the gap's much greater, and offenses where it's almost non-existent. But obviously, this is a problem which is still there. And as with other agencies in the criminal justice system, the CPS, for example, has done a lot of work looking at the possibility or taking steps to prevent any differential charging decisions relating to the ethnicity of the suspect, person being charged. And the council's taken the step of warning judges and directing them to the Equal Treatment Bench Book to learn more about the problem. And of course, these warnings go into the guidelines where robust research by the council and independent scholars has demonstrated a differential. And so that's another benefit, I think, of a guideline scheme. So you may say, well, what effects has it had beneficial effects? And I'll just make a couple of comments here. One good way of asking whether it's a useful aid to sentences is to ask sentences themselves. This council research, where they asked about 1,000 sentences, the question that you see in that figure, and the response is pretty positive, particularly on consistency, but also to a degree on transparency and fairness. So this kind of, that's the experiences and attitudes of sentences, but it supplements research from independent academics, which have shown benefits in terms of reductions in disparity and some increase in proportionality. One of the things that I tested with Jose Pina Sanchez was whether the guidelines might lead to a Procrustean effect. You have these categories and you have cases bundled in. And so you might have two cases which are actually quite different and they were put into the same box, as it were. That is a potential problem of the sentencing grid. So we did an analysis before and after the introduction of guidelines, and we found greater individualization, more factors being cited by the court, mitigating factors in particular, after the introduction of the guidelines. So we didn't see any loss of individualization. And Kevin Cheng, lawyer from Chinese University in Hong Kong, done a lot of work on the English guidelines, and just published a piece, excuse me, just published a piece in Legal Studies, very detailed analysis, and you can read his conclusion. So I suppose my conclusion here to all this is that the guidelines are a benefit to the English sentencing regime, and we're better off having them, the guidelines in the council. In that respect, we're better off than in 1986. Some questions remain, and I've put up a couple here. We still don't know much about the perceptions of defendants or victims. Litigants going through the system, what do they think about these guidelines? Do they think that, do they subscribe to the view that probably it's fairer because they can see the process and their lawyer can explain the steps and so on? Tom Tyler's work on legitimacy would argue that if people understand the way that a decision is reached, they're going to be more satisfied with it, independent of the outcome. Is that the case? We don't know. And nor do we know whether victims feel more confident in the sentencing process, knowing that the courts follow guidelines. So let me turn in the remaining minutes to the Act, the future. A few key elements. The presumption in favor of suspended sentences instead of short prison sentences, 12 months or less, increase in the maximum period of suspension, new possible requirements for sentences served in the community. That's coming in later this year. An increase in the maximum duration of deferred sentencing from 6 months to 12 months, and earlier release points. And I think that it's important to acknowledge the government's taken some pretty bold steps here. The presumption against short prison sentences has been advocated by academics at least since 1949. Various groups have advocated such a presumption against short sentences. Scotland, of course, implemented such a presumption. Germany and various other European jurisdictions have implemented presumptions against or prohibitions of short prison sentences. And deferred sentencing is a useful sentencing option. I'll come back to it later on. It's a pretty modest change, 6 to 12 months. 12 months is the common law norm, I would say. Most jurisdictions have a 12-month maximum period during which the sentence can be deferred, sentencing can be deferred. But in these reforms, there are clear dangers, I think. Here's the presumption. And so you may say, well, okay, well, short prison sentences, what's a short prison sentence? how short is short? And people have different opinions. 3 months is short, 6 months, not so short. 9 months, who knows? So what about 12 months? Well, I mean, one definition of a short sentence would be a statistical definition. Take the distribution of sentences and cut it somewhere and say anything under this threshold is a short prison sentence. And then you could say, well, we'll define a short prison sentence as the bottom 25%, maybe. I mean, if you're looking at salaries, okay, what's a low salary? Well, it's the bottom 25% annual income or whatever. But if you look at the prison sentence then, so you'll see that the 12-month threshold accounts for approximately 2/3 of custodial sentences. That's a very high threshold in terms of the volume of cases that will be affected by it. That's why I call it a bold move, one that has been supported by academics over the years. But it sort of assumes that the current suspended sentence order regime is adequate. Is it adequate to accept a huge increase in the volume of cases receiving a suspended sentence order? Our probation service is prepared for this additional supervision. That there will be probably more requirements placed upon the more serious cases. So will that trigger a higher breach rate? And there's no real evidence that the government's done a lot of work in that area. And I would be apprehensive. I'm an advocate of suspended sentences. Not everybody is. Some academics are quite skeptical of them, expressing the view that if you're not in prison, it's not a prison sentence. They call it something else. And I think it's illegitimate. I think there's a place for a suspended sentence of imprisonment in the sentencing regime. I'm an advocate of it, but it clearly has the potential to attract even more public criticism of the regime in general and suspended sentences in particular. So let's pull this. It's not on the issue of suspended sentences, but these are the kind of media headlines that are going to be popping up with respect to suspended sentence orders. And there's a clear representation, if you look at media stories on suspended sentences, the impression the public's going to get of them is not very positive. So I got 3 pictures here. This is a happy mother and son, mother and daughter. Here's a father and son whooping it up, and a happy couple. And these photographs are all from newspaper articles, and these people have all received a suspended sentence of imprisonment. One can understand their relief if they were facing a term of immediate imprisonment. But that raises questions about parity. It raises questions about the experience of the suspended sentence order, whether it actually can be or is the equivalent of a term of immediate imprisonment. And I think it's a sanction that's got to be handled very carefully by the courts and hopefully responsibly covered by the news media. But I would be apprehensive about it. So I think we're going to see some pretty brutal headlines as some of these more serious cases attract a suspended sentence order. Because if you look at the caseload, the 12-month, the people receiving a 12-month prison sentence, there are some quite serious offenses in that range. Deferred sentencing, I'll just note that it's a useful feature, and I'm glad that the ceiling has been raised. 6 months is far too constraining. Why not give the defendant some agency to take the steps necessary to reduce the likelihood of reoffending, perhaps to make some voluntary compensation to the crime victim and so on, and thereby obviate the need for imprisonment, thereby accomplish some of the goals of the sentence that would be imposed. So I'm glad that's in the bill, and hopefully it will increase the volume of deferred sentences. In Nigel Walker's time, there were about 10,000 cases deferred every year, 10,000 deferrals. They don't even collect statistics on them now routinely. A couple of Freedom of Information requests have uncovered that there are about 800 now a year deferred sentences imposed, deferrals accorded, and this may increase that number. So let's talk about the democratic deficit. I'll end and then open up to comments. So this is the government's statement about one element of the bill, the Sentencing Act, which effectively introduced a legislative veto over the council and its guidelines. And this is what as you can see, the government said. There's a historic democratic deficit, and one wonders about that. Here is the legislation. The Lord Chancellor, an elected politician, must approve the business plan of the council. And the business plan is everything. It's the guidelines that they're working on, the research, it's everything. And the council must seek the consent of the Lord Chief Justice. Well, obviously, the Lord Chief Justice heads the council, so it's not something that they would be seeking. The Lord Chief Justice is there, occasionally attends meetings and so on. The Lord Chancellor must approve these guidelines. And this is done, according to the legislation, to maintain public confidence. I wonder about that. This dispute came about on the issue of sentencing visible minorities. The David Lammy review, very well-respected report, talked about racial differences in sentencing outcomes, and David Lammy's report said it's particularly important to have as much information about the defendant. And he stressed the need for pre-sentence reports. And so, after some research and development, the council proposed guidance. And as you can see there, they basically said in their proposed guideline that a PSR may be particularly important on a discretionary basis for a range of profiles. As you can see, I've highlighted the one profile or cohort, as they refer to, which attracted huge media attention. Opposition parties claim this was two-tier sentencing. And there was a meeting between the Lord, this is all matter of public record, the Lord Chancellor and the Sentencing Council. The Lord Chancellor expressed her views, although her representative had attended every council meeting and participated in the discussion. She expressed her opposition to this guidance, and the council decided to elect to invoke its discretion in the Coroners and Justice Act to proceed. And at that point, the Lord Chancellor elected to legislate effectively to excise this from the guideline. And that was followed, that disagreement was followed by the bill and then the Sentencing Act, where, as you saw, the Lord Chancellor now has this veto over the council and its work. And I think it's regrettable. I think it's an affront to the independence. This Sentencing Council is a primarily judicial body. It is a independent, statutory, non-departmental body. And should it be subject to the approval of the Lord Chancellor? Are judges likely to be happy working, devising guidelines, knowing that an elected politician will have to approve their work? Lord Timpson, who's done some great work for offenders returning to the community, made this statement in the House of Lords. You can see, keen to support the council introducing these measures to maintain public confidence. Was that the case? I mean, it was not clear that there was ever a public confidence crisis in the council. there have been several public opinion surveys asking people about the Sentencing Council. What do you think? Do you think it's a good idea to have guidelines, good, bad, and so on? And those polls have shown strong support for the notion of guidelines. And having a politician decide whether a guideline should proceed or not, given that politicians, according to the last poll that I saw last year, were ranked 41st in terms of public confidence. There were 41 professions ranked, and judges were number 2. Just seems unlikely to me. I give the last word on this to Lord Burnett in the House of Lords. I think that captures the problem. And it also makes you think, well, if the council is a body issuing guidance, there's another body issuing guidance. And that's, of course, the Court of Appeal, which has always traditionally issued guidance for courts and continues to do so, along with the council. What's the distinction between the two that makes it necessary to have a political veto over one? Of course, nobody's going to suggest any political interference with the Court of Appeal. So I had some comments or suggestions for reform, but I would really like to open it up. I'm just going to mention 2. Something has to change on public legal education in this area. And I think that the issue of sentence length is something we have to try and move the public on. And sentence length is rather an interesting issue, because you could take a case. There was a case from the Court of Appeal where there was a care worker. She went around to care homes and people living at home independently, providing services. And she was caught on CCTV taking money from a vulnerable patient, client. She was convicted of theft. The amount was £30. She was of a previous good character, no prior convictions. So obviously there's a very serious breach of trust and highly vulnerable victim of the offence. Her sentence of immediate imprisonment of 6 months was upheld in the Court of Appeal. And, people will disagree. Some people will say, well, we probably could have punished her more effectively and more restoratively in the community with a tough suspended sentence order or something like that. Other people will say, no, that breach of trust is too much. There has to be a term of immediate imprisonment. So there'll be disagreement there, but there may be some agreement. People who think that woman should be imprisoned for 6 months may be convinced that 3 months might be more appropriate. Or if you're thinking of longer sentences, somebody's going to prison for 18 months, that's a serious crime. Does it have to be 18 rather than 12? Where do these numbers come from in the guidelines or from judicial practice? So, maybe there can be some movement in terms of public opinion on sentence lengths. And the other thing I would just say is that, a number of people have argued for an independent advisory body, which would report possibly to the Justice Select Committee, House of Commons Justice Select Committee. The Gore Independent Sentencing Review recommended that. Academics and advocacy groups have all recommended that, but that was one of the very few Gork review proposals that didn't make it into the Act. And probably you can imagine why, given the politicization, as I call it, of sentencing practice. But I'm going to stop there and open it up to the room, if I may.